Owner control, operations, and shareholder agreements. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Susan Snyder, ACTEC Fellow from Chicago. Owner control, operations, and shareholder agreements. To learn more about this topic, you will be hearing today from ACTEC Fellow Kevin Matz of New York City. Welcome, Kevin.
Well, thank you, Susan. So we're going to talk today about buy-sell agreements and planning for it. And that is a very complicated area of the law, because not only you're bringing to bear knowledge of the legal environment and tax, but you're also bringing to bear psychology and working with people, working with business owners who really don't have a sense, they kind of get it, but they don't fully understand that at some point they will die. And they have to have a succession plan for their business, and interweaving estate planning with succession planning. And also you talk to business owners about dying. So, there are other topics too that relate there. What if they become disabled? What if it's a temporary disability or a permanent disability? How do you plan there? So that's the nature of the discussions that we have. A lot of it is really psychology. The hardest part, you can lay out the standards, you can then interweave the tax. Well, if time permitted, I talk more about Section 2703, which governs valuation for estate tax purposes of buy-sell agreements and whether or not they will be effective for estate tax purposes. Time will not permit. But that is part of the analysis and part of the steps involved. You really got to focus on the psychology of the client. So I'd say first off, the most important thing right off the bat is identify who that client is. So is it the entity, in which case maybe you're telling everyone who's an owner that they should get their own separate counsel? Or is it the senior family member who's brought you in? You have to be very, very clear as to that, extremely clear. Because if you're not, it could raise ethical issues, create uncertainty, create possible liability type concerns. So first you have to identify who that client is. And let's say it's senior family member. Let's just go with that. You have to have frank discussions. Frank discussions along the lines of, okay, you have two children here. One of them seems to be very much involved in the business. One of them is not so involved in the business. One of them may be married to a son-in-law or daughter-in-law you're not too fond of. We have to think of various permutations. What can happen? What if someone wants to get out during your lifetime? Someone wants to transfer their interest. Are there going to be any restrictions on transfer? Can they just sell it to a third party? Can they transfer it to family members, including a spouse? Or do you want some sort of limitation under the terms of the agreement that basically says, no, you can't do it unless you maybe have subject to a right of first refusal by other interest owners who can just go ahead and buy you out at perhaps the offered price. So you have to think in those terms too. Restrictions on transfers, keeping it in the family, and then defining what do you mean by family, Not all children, grandchildren are equally capable of stepping into roles of business owners. If father were to die, if senior family member were to die, well, those issues come to bear too. So let's say it's a situation, senior family member owns the lion's share of the interest, and there are two kids. And he wants economically to provide for them equally. But one of the children is much more involved in the business than the other, much, much more. Do you provide equally for both of them in equal shares so that there may be a stalemate in operations going forward and a stalemate that essentially will cripple the business? That is a major, major concern. Or do you provide otherwise? Do you maybe try to provide economically the same, but you give the voting interest to one child who seems to be very much enmeshed in the operation of the business, and give something else? Maybe there's another pool of assets. Maybe there's life insurance. Maybe there's a pool of assets funded by life insurance or other liquid assets that could be used to fund some sort of equivalent type bequest under the terms of one's wills or estate planning documents to the other child. That has to be considered, because you really, when you're meeting with the client, Susan, you really have to be very clear that here's the scenario. You're no longer here. It's your kids. And maybe there's a spouse too, and providing via Q-tip trust for the surviving spouse. How are things going to work? How are things likely to play out? And what is needed to make sure that it doesn't go off tracks? Because we all hear the stories. There are so few businesses that make it down a generation, and then even fewer, so few that make it down too. What can we do to buck those odds? We need to really provide the senior family member, our client, with realism there. And then that's a starting point. Once we have that, we then consider whether or not, if there are existing interests that are already held by the younger generation family members, whether to bring them in, maybe suggesting that they have their own counsel, because otherwise I'd be concerned they would think that I'm the lawyer. And I'd be very clear with them that I'm not, but no matter how clear I am, and I always want to document things with an engagement letter, and even though my emails, my letters may say, understand that I'm not your lawyer, I want to be very clear that they know and have in writing that I'm suggesting them they get their own lawyer to look at this. And that's something that has to be considered. And sometimes you'll mention that to a senior family member, and they'll say, oh, I don't want them to have their own lawyers and come into this with their own lawyers, and all of a sudden we're going to negotiate this. This is my business. I control this. That, again, you have to have those discussions. And one more thing, one parting item for this podcast I'd like to mention. It's great for your client to put together a very elaborate plan. And let's say the client decides, well, I'm going to deal with it mostly for when I die. And whatever my will says, that's going to be it. Maybe I'll have inter-rorum clauses. Maybe I'll have 2 different funds here, have the life insurance, irrevocable life insurance trust being used to side fund, provide a side fund, so this way you could have economic equivalence. But communication is the key, because what's going to happen? What's going to happen if this isn't communicated to the children in this situation? Senior family member dies, and one is going to be very pleasantly surprised, or maybe not surprised. Maybe that's going to be the expectation. The other is going to be very disappointed, and not just disappointed, but disappointed coupled with surprise, but here not in a good way, and that could wreak havoc as far as family relationships going forward. Of course, as a lawyer, you're right. You are in the air. Basically, you're the one to blame, according to them. Of course, so you have to be mindful of that. But that is a major concern. And how do you possibly avoid it? Not to say it's necessarily avoidable, but what you do is you have to communicate, or at least suggest to your client that he or she make very clear during the client's lifetime that these are his or her wishes, and that the purpose of one's estate planning documents and buy-sell agreements, to the extent that they're incorporated, is to achieve that result.
Thanks, Kevin, for your best practices on buy-sell agreements.
Thank you for listening to ACTEC Trust and Estate Talk, the podcast about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this station on iTunes, Stitcher, Google Play, or wherever you download your podcasts. And follow us on Facebook and Twitter at ACTEC Talk.